judge was taking a bit.
So the panel is required when it delivers its recommendations to us to ensure that all the provisions of the Resource Management Act are complied with. If it had applied the wrong test and therefore drawn the wrong conclusion in that context, that might be an error of law that could be open to challenge through this process.
Right. So if we're looking to reject something, we can't use that same kind of method, look for points of law that could be challenged. Are we doing that as well as a council? Are we checking on their points of law?
I wouldn't have envisaged that we were reviewing the panel's decision for that purpose.
So I think I can see what Councillor Casey's asking for. So there needs to be some sort of presumption or some feeling of security about the panel process and what's handed to us. The points of law or the disagreement around points of law are purely then in the hands of submitters and their lawyers to endeavour to uncover. We have to have some sort of presumption of
that's
good
right.
process.
Council in the 20 working days is entitled to assume and rely on the panel's work in relation to delivering us something that complies with all of the Resource Management Act requirements. So we can't be expected to second guess all of that. So we're entitled to assume as a baseline that that's satisfied. Even if somebody in the public raised a question about that, that would not be of itself, because people can question everything, of course, a sufficient basis for us to conclude that we should agree and put our process on hold. That we're not given an ability to do that in the 20 working days.
Shall we carry on? Some of this might become clear, but it's good to make sure
so just
everyone
one point. So
understands.
the appeal period runs from the time council makes decisions. So it is appeal rights for and for persons other than council, effectively.
For how long after the 19th of August?
It's the standard 20 working days, isn't it, for the appeal period? Yeah.
Is that the same for judicial review?
No, judicial review, there's no specific time frame, but in judicial review, the courts have a discretion whether or not to grant relief. So if somebody sat on their hands for a long period of time and did nothing, it would make it more unlikely that the court would exercise its discretion to grant relief, even if the merits of the claim had been, not the merits of the procedural issues had been determined in favour of the applicant for judicial review.
I should just add, as Catherine noted earlier, there are separate rights of appeal for designations, and there's a different time period there, 30 working days for designation appeals, but otherwise 20 working days.
What does it mean if there are appeals? Obviously, this affects the ability of the plan to become fully operative. So it can't be fully operative until appeals are resolved, any appeals are resolved. And particularly those parts that are the subject matter of the appeal are the specific parts that would not be operative. What that would mean is that legacy plans would remain in effect. For consent applicants, what that means is that they would have to apply under both the legacy plan provisions for consents and the unitary plan. So that's a regulatory impact on applicants and also on council as the entity that has to process and decide such applications.
Oh, Councillor Cashman.
Thank you, Madam Chair. Catherine, so conversely then, parts that aren't appealed are then adopted as the new law for the council's processes?
That's right. So
the legacy ones fall away?
That's right.
Okay. All right.
Any other questions?
Thank you. If any, Councillor Darby.
Just interlinked, just following Councillor Cashmore's question, which is an interesting one about when something's adopted and the others fall away, but the old rule book was written quite differently, and I'm fascinated by the interlinking of things whereby you have to read that, say, whole section in full and apply it, yet there's a new plan in place that where there's an adoption of a rule that affects how you read what's left over, if you know what I mean. How is that dealt with?
I think it's...
Do you get
it's
the drift?
complex. There's a bit of crystal ball gazing involved at this stage until you've seen the appeals, how they're framed, how broad they are, which parts of the plan are potentially impugned. So it's a little bit difficult to unpick in the abstract, but Catherine's right, there's a provision in the RMA which says that once rules are no longer subject to appeal, they're deemed to be operative, and the previous legacy provisions, the equivalents, fall away. Perhaps easier said than done, and I agree it can be difficult to unpick, and that's going to be a work stream in its own right, trying to identify which parts of the plan can be regarded as operative as we move forward, and which parts still remain.
Okay, thank you.
Post.
I think that might get clearer to us as we proceed. Penny?
And I think the comment that needs to be made with this is that when we talk about legacy plans might still be applying, we need to remember there are 7 legacy district plans. So it's not just a matter of looking at one legacy plan to understand the difference between the two. It will mean the resource consenting staff need to maintain 7 legacy plan provisions for those provisions that are appealed. So it does become a very complicated management process going forward.
Okay. Councillor Casey, you had a question?
2 questions from earlier on, sorry to go back, but in an early slide it said we've got to take cognizance of the RMA, particularly Part 2, and any other planning documents. What does that mean?
National policy statement.
There are a range of planning instruments which could be relevant. The New Zealand Coastal Policy Statement, for instance, is a good example. The plan to give effect to that instrument. The Auckland plan, of course, is something that needs to be had regard to as well. So there are a number of instruments. It's probably worth dealing with the narrow scope of the exercise if you're accepting. If your inclination is to accept a recommendation, then you need to know more, because the legislation requires the panel, the independent hearing panel, to certify that it's gone through all this for you. It's really when you're considering rejecting a recommendation that you're really having to
Then you
drill
look
down.
at all the planning documents to see where you can find a reason to reject. That doesn't mean, oh, that's good. I had another one, just one sec. Sorry, I should have asked it at the time. I might ask you to ask it when I remember.
If anything else comes up, please ask it. That's absolutely fine. Right, next.
Oh, I've remembered it.
Oh,
Sorry.
hang on, Councillor Casey.
Right, here's a recommendation from the IHP, and I like the first part of it, but not the second part. Are we able to do a bit of juggling? So this is one sentence, one recommendation.
Yes. Yeah, I think you may, again, we're sort of looking at things in the abstract here, and we don't know what we're going to be dealing with, but potentially you're then having to reject, potentially, but in rejecting, you can accept parts of the original recommendation, and this then has an effect on the scope of appeal rights. It's probably a little complicated, but your appeal can be limited to the difference between the recommendation from the panel and what you're taking forward as the council. Hopefully that makes some sense.
No, I don't understand.
But you'd probably be having to reject if there's a recommendation and you part accept it, part reject it. It doesn't actually strictly provide for that, but you'd probably reject and maybe define the extent to which you're rejecting, so as to make it clear what parts of the panel's recommendation remained in play.
So then when
Probably
it
it's
says,
difficult to look at in the abstract. I think it'll be easier, hopefully, once you've got actual...
Councillor Casey, can we, I think, I totally understand the question you're asking. I do think we might have to wait, though, till we see the form of the recommendations. We are asking our advisors to do some crystal ball gazing that's kind of really
We're doing
hard
too.
to do. Well, you know, I think we've got the 27th for the content briefing, and then we've got the ability to, we've all, you know, many councillors have raised questions, they've put them in writing, they've made it clear to the staff that these are the issues that they're going to want to drill into. I think that's the time then to sit and get that information and have a look, and, you know, then we enter the debate. But I
It was
don't
just
know
in
if we can
relation
answer
to
your
us
question now.
finding an alternative solution if we don't like a recommendation. So if we half like it, we only need half a solution.
And the answer is, once we see the form of the recommendations, we'll know if that's possible or not. So let's work on that. Happy to, you know, if you want to keep talking to Catherine about that, that's fine.
It might... Oh, no. Okay.
Okay. Conflicts.
So what I've got here for you is just an outline of what we're going to be covering today. It's a refresh of highlights from some of the Office of the Auditor General guidance with which you're already familiar, relating those at a very high level to the unitary plan context, and then having an outline of assistance available to you both through council itself and the separate conversation that you'll have with the Office of the Auditor General about how they may be able to provide further guidance and assistance in this process. So why are we doing it now? It's just good governance, but particularly as we're coming into a series of decisions that are very important for Auckland, we thought you may find it helpful to run through these. The context in which we're coming to this is that governing body and committees routinely make regulatory decisions under various acts, including the Resource Management Act, and always require you to consider whether you've got any financial or non-financial interest to declare, and it's a standing item of our agendas for that to happen. The unitary plan decisions are similar to plan change or operative plan review decisions, but I wanted to emphasise in this context, this is one plan for Auckland that is vertically integrated. So when you've been making decisions previously on other plans or plan changes, you've been looking at things in a slice or an element of the planning framework that applies. Here you will have before you one set of rules that will apply from the regional policy statement down to the district planning rules, and that provides a different context in which it will be important for you to understand and consider any relevant conflicts. Our last point there, legal services and the Office of the Auditor General can provide relevant assistance in addition to the material that's available to you electronically. The first point, and it is a really important point to raise here, is that conflicts of interest are natural and unavoidable. The quote there, New Zealand, we are a small country. Conflicts of interest in our working lives are natural and unavoidable. The existence of a conflict does not necessarily mean that someone has done something wrong and it need not cause problems. And that's really important to bear in mind. Just because somebody has a conflict that they have to manage, it's not a question of fault, it's something that naturally arises. The key is identifying and managing them. Here we've got a quote from an inquiry the Office of the Auditor General did in relation to matters in Ashburton. And I just wanted to emphasise here, the reason I pulled this out for you is that conflicts of interest here are, and many commentators on conflicts will make these points, as do numerous judicial decisions, that conflicts of interest are more likely to be grey than black and white. And the point there, that where an elected member has a potential conflict of interest, they need to weigh a complex set of competing concerns. Unless there is a clear financial interest, in the end, each member will need to make their own decision on whether it's appropriate for them to take part or to stand aside. Here, just guidance on careful management. Not a simple set of rules that I can pick up and give you and tell you how to do it. It's all very context and very, very personalised.